6 years ago, an American manufacturer of medical products, MedPro, entered into an exclusive contract with an Indian company, Mumbai Partners, to distribute pulse oximeters in southern India. Oximeters monitor the condition of surgical patients under anesthesia. While the oximeter itself costs nearly $1,000, the real profit lies in supplying the contacts, or probes, which must be replaced each time the equipment is used with a patient. The written contract stated that either party could terminate the relationship in any of 3 ways: for cause, on 90 days' notice without cause, or on the September anniversary date each year. For 2 years, Mumbai worked to persuade Indian hospitals to use the MedPro product and obtained approvals for its use from hospital regulators. 4 years ago, Mumbai made its first MedPro sales, amounting to $100,000. 3 years ago, sales jumped to $500,000, and the next year to $800,000. On May 24th of last year, however, MedPro sent Mumbai a letter terminating their contract effective July 1st. MedPro gave as its reason Mumbai's lack of progress in expanding the Indian market. 2 days after the letter was sent, the chief sales representative for Mumbai resigned. In June, he began to market MedPro oximeters. Mumbai immediately sued, claiming that this violated the sales rep's non-competition agreement and that he had schemed with MedPro's manager to steal away Mumbai's business. An Indian court enjoined the representative from marketing MedPro oximeters. Mumbai has continued to sell replacement probes to existing customers, but has made no new sales of oximeters. 3 months ago, Mumbai sued MedPro in federal district court. The parties then agreed to mediate. In this mediation, 2 mediators, Dwight Golan and Marjorie Aaron, work with different groups of litigants to resolve the Mumbai MedPro dispute. The following are brief excerpts taken from different stages of the mediation process. In the Mumbai dispute, the mediators suggested that it might be helpful to meet privately with each client in advance, and both lawyers agreed. The following are excerpts from the meetings.
Well, Chris, Ms. Gandhi, thank you very much for making some time in which we could talk. I think it's really helpful to start to get a feel for how Mumbai sees this problem and what's happened.
And we put a lot of time and energy, a lot of resources, and essentially paved the way for them in India. What we're really after here is some justice.
Well, I got the sense, we talked last week a bit about this, that this was a contract you spent a good deal of time in development costs and activities, and then it's really as it began to take off from your perspective, suddenly it was ended. Well, and I'm not sure I understand a great deal about the context, but that's really what I need to learn about.
Perhaps Ms. Gandhi could speak to that better.
Yeah, I mean, basically we negotiated a contract for a very long-term deal. I mean, it was an exclusive contract. And so the idea was that we were going to be the exclusive distributor of this oximeter in India. That was the idea from the beginning. And I mean, I don't know what happened with the paperwork because, basically we were in the room to discuss, okay, whether our company could meet the needs of MedPro in India, and we decided we could because we had the relationships with the bureaucracy. And I mean, I don't know how much you know about business in India, but it's really quite a different thing. I mean, everybody in India is using all kinds of outdated equipment and they don't really care. They don't really understand why they should use this. So basically we had to convince them that this is money which is worth spending. Basically, I feel that they came, and as soon as we were starting to make profit for them, they took Chatawa from us, and then they terminated our contract.
Chatawa is the person
that was the employee, yeah. That was our employee. He was our top salesperson, that's right.
The subtext of all this, and really it's important to understanding the problem here, is that there was some collusion going on here.
So you see this as an intentional violation of the contract as opposed to a misunderstanding or things not turning out as you hoped?
I mean, yes, I would say yes.
And your sense is that MedPro knew this was happening and was at least content with it. It sounds like an awful situation given the years of work that you had put into this.
I feel that MedPro's part in that needs to be, they need to understand they can't just do things like that.
So help me understand, when Mr. Chatawa left, what has happened since then with this?
Well, I mean, that is really part of this whole thing. The problem is that he left, Mr. Chatawa left, then the MedPro decided they're not giving us the equipment anymore, right? They're giving it to Mr. Chatawa now. So customers are calling us, asking us for these machines now because we've done all the work and now they want the machine and they're calling us. And I mean, it's been really quite embarrassing actually.
Well, I think it's important that MedPro understand your perspective and how you see this and what needs to be done.
Well, I'm glad that we have this opportunity to get together before the day of the mediation session. I don't know, have you ever been involved in a mediation before?
No, I haven't.
Okay. Many mediators don't do this. In other words, they just start off that day in the same room together. I think it's helpful, for particularly in a case of some importance, to get to meet with both sides first. I get to know you, you get to know me. I want to review some of how things look from your perspective. The other purpose of today's meeting is both to figure out how we'll work together, but also to think about how you might prepare best for what's going to be on the day of the mediation. Sometimes what I do is, after I then have a meeting like this with the other side, I will call you and say, based on what I heard there, I can't tell you what I heard there, but based on what I heard, maybe it would be helpful if you brought this information or emphasized this, that, or the other point, okay? My first question is really pretty open, which is to say, tell me a little bit about your perspective on this dispute. I know you didn't want to be in one.
It's frustrating. I mean, these guys didn't do their job, basically. And then they look at a contract that they negotiated,
Right.
which says that we can get out of the contract for any reason, and they get upset at us for getting out of the contract when they weren't doing their job. We wouldn't have pulled out for no reason, but that's what the contract says, and they gave us a reason. So, personally, I don't understand why we're going to have to shovel out a lot of money on this.
I think Frank is expressing frustration and anger, but there are actually sort of logical reasons for that.
Look, they failed, all right? We had an agreement. The agreement was that they were going to sell our products. They couldn't. They couldn't sell our products, all right? And that's a competence issue. That's clearly something we can break the contract for. They, as Rosanna was saying, they are competent players in this industry. They negotiated a contract, and now what they want to do is hold us up because they know that we're losing business every day as this goes on. They know that we can't act until we resolve this, and so they want to be paid for their failure. And that's the frustrating part of it.
So you wish they would act like grown-ups.
And go away.
And go away, yeah.
Sure,
And you've got three sources of news you didn't want to hear. One is your business is down in a way that you didn't want it to be because of them.
Right.
They're asking for lots of money in the lawsuit. I know you've talked about that. And oh, by the way, it's going to cost you a bundle to defend your right to not pay it.
Just to get to the end, just to get to where we think this would end if we litigated it.
Right.
Okay, well, let's see what we can do. Well, thank you all for coming. It's delightful to meet all in the same room and finally move toward resolving the dispute we've been talking about on the telephone. It occurred to me that folks don't know each other in person, and so perhaps it makes sense if you would introduce yourselves. In my view, anybody that comes to a mediation has a decision problem, a pretty practical decision problem. And the question is, will you be able to come up with a resolution, come up with a settlement that seems to be better for you than what your other choices are? That's the decision. A few little reminders, and that is that I've previously circulated a mediation agreement. Everybody has signed it. The most important piece of that agreement is confidentiality. Each side has information that the other does not. So I think it would make sense now, and I've explained when I spoke with you previously, for each side to lay out how it is that they view the dispute, what your perspective on the legal issues are, on what happened from both sides. I'm going to turn the floor over to you.
There are really two layers of what's going on here. We have a sense of unfairness, and that is being betrayed, and we had an agreement and an understanding that we were going to have a long-term business relationship with MedPro. And that contract, in essence, was a handshake and an understanding, look somebody in the eye and make an arrangement. And we invested in that arrangement. And we were understanding that they were going to invest in that arrangement as well. And so my client put just a lot of energy and resources and time investing in that relationship and developing the market in India for MedPro, with a clear understanding that we were investing in a long-term relationship and everybody was going to benefit from that.
Counsel went on to give an overview of Mumbai's legal claims, arguing that the plaintiff was entitled to damages equal to 5 years' lost profits on its projected sales. Following the lawyer's presentation, the mediator turned to Mumbai's CEO.
Do you have anything you want to add?
Well, I mean, I think that is basically the case. I think what I would say is that, part of this is from the initial conversation that we had to start this contract, and Mr. Cooper was not there. And the entire meeting was about this being a long-term exclusive contract with Mumbai Partners, which means we would be the only company selling these oximeters in India. And in order to do something like that in India, you have to do a lot of initial work. I mean, basically, without us, there would be no Indian market for oximeters.
Tell me if I have it right, that this is different than regular marketing of a product. In other words, the people in the hospitals who make the decisions to buy this have to understand how to work it.
Exactly. I mean, it's a new technology.
So you would have had a seminar or some kind of event day where you showed people in a hospital how this works, and now you see them on the street and you can't. I really do very much understand and appreciate the candor with which you've spoken, and I look forward to hearing what you have to say.
Obviously, we have a different perspective, and just want to outline that if I can. We had extraordinary hopes for the relationship between MedPro and Mumbai and for the sale of this really remarkable, innovative product in a country as large as India. And the bottom line is that those expectations were just gravely disappointed. We did wait 5 years to see whether their promises about the marketing that they could do for this product would really bear fruit. And unfortunately, quite disappointing performance. I mean, this is about a business relationship. There were conversations and promises exchanged, but it was reduced to a contract. Mm-hmm. And the contract clearly sets out multiple mechanisms for termination, because we understand that things sometimes don't work out as expected.
Ms. Gandhi raised the question about Mr. Cho, and I know that he's a sort of figure in this story. Can you tell us a little bit about where Mr. Cho is?
Mr. Cho's been transferred to China, again, to launch this and other products in that market. And I understand that there are some allegations out there about his role in the dispute with the employee, and I understand that if that were to be true, that would be a concern, but I don't believe that is the case.
Well, I know that one of the points that you folks have been making is, or suggesting, is that maybe somehow Mr. Cho and Mr. Chadwa got together and sort of purposely reducing the sales. And I don't know if you have heard about that or talked to Mr. Cho about it, but what's your view on that?
Well, I mean, first of all, that just doesn't make sense. I mean, okay. Our goal is to sell the product.
So, and you're kind of saying that from your perspective, it doesn't do you any good to see sales numbers go down instead of up. Is that?
Absolutely.
Why don't we, sort of from a broader view, suggest what this looks like to your eyes and ears, and then I actually do want to pin down some of those things. How about that? From both, okay?
Okay, I don't want to duplicate what my counsel
Sure.
has said, but the bottom line here is, we were trying to introduce ourselves to India through this product, and we have a lot more products that we want to introduce to India, and they're harming our ability to introduce ourselves to India. There's a real problem here. you know, there's no way that you can say that MedPro is doing this. You know, if Cho has some kind of scheme that you think you have proof of, that's Cho. That's not MedPro. MedPro has no interest in doing that. MedPro is interested in selling more product. So the idea that we would be consciously dampening our own sales doesn't make any sense. That hurts me when I go to my higher-ups.
After the lawyers and parties presented their perspectives, the mediator posed questions intended to highlight areas of agreement and disagreement.
What I'd like to do is, while we're all together, figure out what we agree upon legally, or if there's anything that we agree upon legally, sort of if then. Okay, so let me see if I can pin you down a bit. Here's my question. Okay, if somebody could establish that Mr. Cho and Mr. Chadwa went to a bar and said, "Hey, let's drive the sales down by half," okay? And because we know that if we drive the sales down by half, I'm not saying this happened, but if they did, and someone could prove it, we drive the sales down by half, I'll get my employer I'll get MedPro to cut them off, and then you could just assume they did that, and they did it a year and a half before, okay? And in fact, they got the sales down by half. Would that not create a legal problem for you? In terms of, then you terminate them for cause because the sales are down. That would be a problem.
Well, and that would be an entirely different legal theory.
Okay.
But if that
were
to
true,
happen, that would be a problem. I assume interference with contractual relations.
You would have
bad faith, intentional tort.
Right.
Yeah, but I feel like we have
so unrealistic that I feel like this is a red herring.
Okay, let me ask you a sort of a legal question. If the facts came out, if it were true that Mr. Cho didn't have any involvement in driving sales down with Chadwa, they hadn't met in a bar, and that what happened was Mr. Chadwa, for a year or so, decides to depress sales. And then toward the end, emails or talks to Mr. Cho and says, I'm leaving Mumbai, and I hope that I will be able to continue to represent your product when I'm at Mumbai. When I'm not at Mumbai and when I'm at BHS. Then, as a legal matter, would you have a bad faith claim against MedPro?
I think your point is well taken. At that point, I think we would have issue with that theory of liability.
So if you could establish that Cho was really involved in trying to set up a decline in sales, that would be a problem for them. But if Mr. Cho or anybody from MedPro was really disappointed in the sales, and it was Chadwa's doing, then legally that undercuts a bad faith version.
I think that's a fair point.
Okay, all right, I just want to make sure. So we agree, actually, on the legal theories. What we don't agree and what we don't really know a lot about is exactly what happened, because we haven't had full discovery on those issues.
This excerpt shows a different approach to conducting an opening session. Here, the mediator works with different players, still in the context of the dispute between Mumbai and MedPro. We join the session at the conclusion of the mediator's opening comments.
We usually start together, and then at some point it makes sense to split apart so I can talk to one side or the other side. And in our time together, first I'm going to ask each side, basically, without trying to give a formal opening like you would in a courtroom trial, to describe the key points you think the other side should keep in mind as we go forward to settle this. And I know you're going to have to be fairly frank about this, and there may be things you hear that I'm sure you disagree with. Any questions?
After confirming that the participants understood the ground rules, the mediator invited each side to speak. The following are excerpts from the presentations.
I think it's important for us to recognize that there was a tremendous amount of work that was put into the entering of the contract and the introduction of MedPro's product by Mumbai into India. We also think it's important that there were clear understandings between the parties about what it would take for Mumbai to introduce this product successfully. It appears to us that there was a conspiracy between one of our employees, Mr. Chadawa, and Mr. Cho of MedPro. Our company was in this for the long term. We fear that MedPro is not in it for the long term, that we were used to introduce the product into the Indian market and then dropped because it was no longer convenient for MedPro. Our fear is that the sales losses are attributable to the conspiracy.
I usually offer the principals a chance, if they'd like, to say something perhaps of a non-legal nature, or you're welcome to not say anything at this point and talk later. There's opportunities throughout the day. So I don't know, Ms. Gandhi, if there's anything that you'd like to say at this point?
Well, I would just like to say that I am very, very upset with all of these things that have been happening. They have not treated us properly. But I do not understand your system, so for right now, I will just listen.
Okay. And as I say, we'll have other opportunities for both sides to make comments as we go on. So I'll turn the floor over to MedPro and ask that you listen as politely and carefully as they have.
Richard, do you
I
mind?
think I'll
if-
defer to
Okay.
Patrick
Yeah,
to speak
so
first.
Fine.
I'm going to let my lawyer talk about the legalities, but I just, you keep talking about a conspiracy between Cho and Chadawa. That just in my mind makes no sense. It's just ludicrous that we would have any desire to decrease sales in the region when we had every incentive and hope that sales would be increasing in India. And our major disappointment was with the sales trend, the declining sales trend that led to the termination. But I also want to say that it's unfortunate that it's come to this. We had the highest of hopes for the Indian market when we decided to use you as our distributor there. And truth be told, in the beginning, I think it's fair to say that we were satisfied with the effort that you put in opening up the market.
Dwight, since I'm going to assume that the basic contract principles are familiar to you, and since Ms. Gandhi has indicated a lack of familiarity with our legal system, I wonder if I might, with all due respect, explain a few things about this situation to you. We included in the contract an escape clause. This was an experiment that MedPro made in creating an exclusive relationship.
Experiment is at my company's cost.
And a substantial
And-
risk for ours as well.
Yeah, I do not like to be called experiment.
Well, I certainly didn't mean to offend you in using that
I
term.
don't like
wasn't.
that.
I wasn't calling you an experiment. I was saying that for MedPro, the use of an exclusive distributorship relationship was an experiment, a way to enter the Indian market, different from where they had in other ones. We hoped that it would work. It didn't.
You keep talking about good faith. I don't see good faith in your actions.
Well, this gives me a sense, which I already had, but underlines that there are serious disagreements here.
Well, may I just, since you asked
Okay.
Eileen to speak,
Sure.
I don't want to keep going back and forth on the same point, but please don't misinterpret our silence when MedPro was accused of bad faith and intentions from the outset of this contract. Please don't interpret our silence as acquiescence to that. MedPro entered into this contract in the hopes that it would be a mutually profitable relationship. We're sorry it wasn't for either party.
Well, I should say, I'm not assuming from the fact that anyone is listening politely that you agree with anything you're hearing. In fact, I know there are very serious disagreements here, or we wouldn't be here. There's always a tension about how deeply to go into the arguments. You're here so you don't have to try the case. But on the other hand, you have to understand what the concerns are and what the disagreements are before we can start to deal with them. So I would like to take a little time. If there are any questions that either side has for the other, not free discovery, you can do that if we don't settle, but things you need to know to make a good settlement decision. I'm going to argue that the other side has some interest in answering the question because you're asking them to make a very tough decision and they may need some information to make it. So I don't know if there are such questions. If they come up now or later, you should feel free to ask them or ask them through me. I don't know, Ms. Seidman, if at this point there is anything.
Well, it would help us to know what Mr. Cho's knowledge was of Mr. Chadawa's plans.
Why don't you speak to that, Patrick?
My understanding is that Cho and Chadawa had regular communications, as they should in any business relationship. But I don't believe Cho was even aware of Chadawa's intention to leave your company until just prior to his actual decision to do that.
Well, you can think about this, and also, as I say, we can have questions back and forth as the day goes along.
I
don't know if you have any.
I do.
Okay.
I have two questions based upon what you both said. The first question is, I presume that your company had sales expectations for the oximeter and the probes. Were they disappointed?
You want to know if my company was disappointed?
I want to know if the expectations and projections that you had for sales were disappointed.
Certainly we would have wanted more, but were we to know our salesperson was trying to delay those sales? We did not know what was happening until after this has all come about.
Really, to begin with, I'd be interested in whether there were any things that you might not have felt comfortable saying in the opening session, but that you think I should be aware of to be helpful.
Well, I think it's important for you to realize that there is some proof out there that substantiates our claim that MedPro and our former employee were working together before all this happened. The chronology of events it makes it clear, and then we have emails we alluded to where there's a conversation, a dialogue going back and forth between Mr. Cho, and Chadawa. And, let's be honest, Cho was their agent. And so even if they didn't know, they're responsible for the actions of their agent.
No, I understand.
So I just want to make sure you know
The
that we think
Cho-Chadawa connection
Yes,
is
I think
considerably stronger than maybe it seemed in the opening
I
session.
think that's absolutely accurate.
Okay.
Yeah, I mean, I'm very surprised. I don't know what dealings Mr. Cooper has had with Mr. Cho, but I mean, I'm very surprised that he's making it seem like, there's no way this could have happened. I understand that it's like the way that they're going to talk about it, but it's just not possible. It's just not possible when you look at the emails, and I'm happy to show them to you if you want to look at them.
Okay.
I think I don't know, what do you think? If it's all right to show?
I think understanding the parameters of this arrangement, I think it's fine to show.
You can decide later whether or not you want me to talk about or show any of those emails to the other side. At the first level, it's simply to bring me up to speed, to make me educated about what really happened.
Okay, then I'm happy to show them to you.
Okay? It looks as if these began about 5 weeks before the May 24 letter. At least these emails.
Yeah, I think that's right.
So this is the last stages, one assumes, of Mr. Chadawa's plan, because he must have hatched it before then.
Yeah, I don't know. These are the ones we have.
Yeah.
But yeah, that is right. The ones we have go back about 5 weeks before Mr. Chadawa left, yeah.
And I don't think we believe in coincidences. And if you look at the date of that letter, it's only 2 days later Mr. Chadawa gave his notice. And I feel very confident we're going to find some other.
We should think about whether, since these will, I assume, be discoverable if you have to go to litigation, whether it might make sense to let me use them at the right moment to encourage MedPro to take this more seriously.
Mumbai's representatives alleged that MedPro had taken advantage of the situation, allowing Mumbai to do the groundwork necessary to build a market, then abruptly terminating their contract as the relationship became profitable.
Sounds extraordinarily frustrating. On the one hand, you're dealing with a disloyal employee. That's pretty clear at this
exactly.
point. You're dealing, as I hear, with a lawyer who's basically arguing a wonderful view of the world for MedPro.
They haven't even decided which part of the contract. I didn't even read the contract, okay? But now I've read it because my lawyers told me I have to read it before this session.
Right.
Okay. Now, they're not even deciding which part of the contract they're terminating the contract. And how can they just we've terminated it. We don't know which part of the deal we've terminated it under, but we've terminated. That's ridiculous.
Well, I am going to have to ask them more about that.
The mediator listened to the Mumbai CEO describe her understanding of the contract and her expectations about the business relationship. He then turned the discussion toward other potential concerns.
Tell me a little bit about your business plan. That is, this was part of a larger plan for Mumbai Partners.
Yes, it was.
You weren't going to be Mumbai oximeters.
No.
So
Yeah, I mean, we had an idea, we have been doing business in basically very small potatoes kind of medical supplies, bandages, that sort of thing. So we're interested in expanding into the more high-tech area because this is the expanding area of medical technology. It also allows us to hire more well-trained staff. But that letter they sent us said, okay, you can have a non-exclusive contract now. I mean, that's sort of like, they're not even giving us the machines. What non-exclusive contract? How can we have a contract at all? We don't have any equipment to sell.
Well, they shut us off, so it doesn't speak to the gap that needs to be filled, and that's part of our damages concern. They're not
Right.
giving us probes right now.
Right. And I gather that the higher end involves a whole level of licensing and acceptance that really doesn't apply to surgical bandages and
Yes.
clamps and that sort of thing.
Yeah, exactly. So we were creating those relationships, and it means dealing with a higher level of the hospital staff, the executive level.
So it sounds like you were expecting to sell the other kinds of equipment in addition to pulse oximeters, other kinds of sophisticated equipment.
Yeah, that was definitely the hope. We were hoping to use the context that we built from the oximeters to launch into other products, into radiology equipment, CAT scans, these sorts of expensive types of equipment. I mean, a lot of Americans are actually coming to India to get surgery
I've
done.
heard about that.
Yeah, so that's actually, so there's a demand now for those kinds of tests to be done.
Would it be the same kind of market entry process that you had to go through for the oximeters?
Yes, pretty much the same. I mean, there are some differences, but basically the context that we've built because of the oximeters, there would be very similar process and very similar people that we would deal with.
Well, thank you for your patience in there, and thank you, by the way. I assume that we took longer than whatever I predicted. Okay.
No problem.
My first question, if you can think back to when we were in the room together, is there anything that you maybe wanted to say in there but decided not to? Anything you'd like to say now that you think I should hear?
I can't think of anything right now.
Anything they say surprise you?
Well, the thing that puzzled me, frankly, was the emphasis that Mumbai's council placed on this sort of other agreement.
The mediator talked at length with MedPro's lawyer and vice president about the legal issues in the case and MedPro's understanding of the contract. She also asked about the company's business goals, when it began its relationship with Mumbai, and at present. After more than an hour, the discussion turned to bargaining.
It would be helpful to me to have a number to go back with.
Well, here's where I am on that, and we've spoken about this. I'm not sure that I really feel comfortable being the first one in here with a number. I would really like to see a number from them that's framed by the realities we've just been talking about.
Yeah, I mean, they did make a formal demand just prior to the mediation, right, of, I believe, $1.6 million. So I know that if I go back in there without a number for you, they're going to say, well, we said $1.6 million, and then what are they going to say?
Well, normally I would understand and read that as an opening proposal, but it's a number that's so unreasonable in terms of what we've talked about, how we would calculate and measure the damages, even if this were deemed to be breach, which we really don't think they can show, that it's hard for me to treat it as a number that we can respond to. And that's why, as I said, I'm reluctant to be what it feels like to me is being the first one in. That
so you're sort of saying it doesn't count?
Yeah, it's kind of a magical number.
A magical number, yeah, it's a magical number. Of course, to them, the magical number is real. Let me just say two things, okay? One is that I do understand that it doesn't seem real and why respond to a fake number. But if we both do that, we're just never going to get anywhere. I'm going to spend my time, your money and time going back and forth and saying, please, can I have a number? Please, can I have a number? And nobody wants to bid against themselves, and we'll just get nowhere fast. So somebody at some point is going to need to step up to the plate. And I think I'm going to have a lot of trouble getting them to do what they would characterize as bidding against themselves. Do you understand?
Yeah, I certainly see the difficulty of your position.
But let me say something positive along those lines, and that is that there's a fair amount of research out there that tells you that the person that puts, or the party that puts the first serious number on the table actually has a negotiation advantage. That first number out there anchors things. And so the first number is important. And so what I'm going to suggest is give me a first number, but when you formulate it, disregard the 1.6.
Just our
Make
own,
believe
our
it's
own
not
sense
there.
of a real first
Yeah,
number.
think about where you think you'll end up. Not where you
It
want
might-
to end up,
it
but
might make
where
them a little
it might
unhappy.
be reasonable for them for you to end up at the end of the day, all things considered. And then pick a first number that would head you there. And then that's what I would ask you to do.
I think this.
You want to talk about it?
We might need
Okay,
to talk
that's
about
fine. Well, I knocked on the door and you said you were ready, and do you have a number for me?
Well, we've talked about the frames of reference that you used, and the number that we feel we can put out there, given all of my concerns and reluctances, is 50,000. And I can talk to that
Okay.
if you would like, and sort of
Yeah.
explain how we got there, what it signifies.
You gave me a number. I asked you for a number.
I mean, we're going back to this kind of worst case scenario that you worked through with us, which is worst case.
Right.
After they show liability, which we don't think they can show, and a measure of damages that's at the far end of these multiple ways of terminating, gets us to 280. That's the outer limit. And I think if this is a number to get us framed, the number that it needs to be is in that $50,000 range.
Okay. Let me just. I appreciate that $50,000 is not an inconsequential sum of money, especially if actually you had the right to terminate in the 30 days. In which case you would either owe nothing or $20,000 or something like that. Am I right? What do you suspect their response will be?
Who knows? That
My problem, right?
I mean, I don't think they're going to be thrilled with
Right.
it, and I think part of what we're struggling with is their expectation of a future business relationship income stream that's just terribly unrealistic.
And you want to send a message that this is not about that. One of the things that worries me a little bit is that they'll hear you're 50 and think, oh no, they'll only ever pay 75 or 90 or something like that. And so I'm worried a little bit that the 50 may send an even lower signal than maybe you would have intended. What do you think about that one?
You know, I'm concerned about it getting up over, and you know, if there's a number or a reference point that you want us to think about, you know, I'm certainly happy to do that.
Let me just say, one of the things that I'm thinking is that if it would be reasonable to settle the case in that 280-ish range, then maybe you would want to start at around 100, which still gives you plenty of room to go up. But, you know, let me just say, and you don't have to do it now, but one of the ideas here is that you want to offer enough so that if they're at all reasonable, which we don't really know yet, but if they are thinking rationally,
That they might come back.
that it gives them enough hope to hang in there. And so that's my concern about the 50, whereas about 100, you know, maybe they would engage a little bit.
Now, I certainly understand what you're saying, and 100 sounds different in perhaps an important way that allows them to have a toehold.
Right, that's what I'm thinking.
And I think we would just need to talk about that.
All right.
No, you go ahead.
We just feel like we can't go above the 50. They're not operating on real numbers, and we don't want to encourage that.
So you don't want to get into real numbers because they're not. Oh, listen, I'm not arguing. That makes sense. I get it. Okay. Could backlash, could not. Let's see what happens. You're clearly sending a message. But let me just say one thing. It's always nice to have a reason for a number. We used $20,000 a month before to come up with the 14 months.
Sure, the worst case.
Yeah. If I look at the 90-day termination idea, that's 3 months. If I multiply that by $20,000 a month, I get $60,000. It might be nice for me to be able to keep them tied to the contract, say you're tied to the contract, and come back with 60. Could you do that?
Yeah, I mean, I guess
Can I do that?
a way of packaging that is to say, it's either immediate termination or an intermediate view is that 90 days. And
Right.
are you
That
comfortable
makes
with
much more
that
sense,
going up? So that would be going up 10 from what we talked about.
And actually, and I can characterize that as good faith. They could have stuck down with the 30, but they're coming up to what would be 90 days. I'll do that. I'll try that.
Okay, that sounds good.
Great.
Well, thank you for waiting. It took me a while, but I wanted to go over each of the points you'd raised with MedPro to see what their response was. And also, they had, of course, had things that they wanted to say from the first session, and I can tell you a little bit about what their thinking is. I do think they want to get this resolved today. I think there are reasons for both sides not to want to spend a lot of time in, I'll call it American-style litigation. I raised with them your strong belief that Chattawa was essentially encouraged to leave you and betray you by Cho. They pushed back pretty hard. They say that as part of sort of their corporate due diligence, they did a scrub of their computer system and their computer records because they wanted to know what emails Cho had sent. And they say they don't see any emails prior to about the 1st of April, which is about 6-7 weeks before the May 24 letter, in which are more than just, I'll see you for our monthly meeting or something like that. You'll have to see that. Now, that still doesn't mean that there weren't meetings in a bar or a restaurant or wherever, but it does mean he was under some corporate pressure to keep his numbers up. I don't know what would happen if you deposed him, but that's a bit of information.
I appreciate the information. I mean, for candidly, we have to take that with a grain of salt.
Yep.
But I appreciate the receipt of the information and the spirit with which you pass it on to us.
I would say that they're not arguing, they're not drawing a line in the sand and saying we're certain that that May 24 letter terminated the contract. They recognize that there could be some argument about whether there was cause for terminating this contract. They recognize that you may have some pretty strong reasons why, in fact, there wasn't cause, that your performance was acceptable, and that there might have been external reasons. They do say that the contract, as written by MedPro, has sort of a 3-tier termination system, as you know. We at the most would be exposed to 14 months from the July 1, when they tried to terminate, of last year until September 1 of this year. So I guess they're analyzing this as damages of somewhere in the little less than 300 to something more than 400 kind of range. And that, I think, is what's driving their thinking. And that's the issue here, as I hear you both, more than really the liability.
Well, what I'm hearing, and correct me if I'm wrong, is that they are acknowledging a real theory of cause of action here, some sort of legitimate cause of action, and so they are starting to speculate about what their perspective on damages are. But I'm concerned, and I'm sure my client is as well, that there's no accounting for future losses.
My figure comes from the idea that there's about 5 years of lost profit here, at least. I mean, the other thing is, they knew that we were doing all of this upfront costs, which we expended ourselves.
Right.
And this is upwards of $500,000 that we've spent on, training, studies, all the things that need to happen in order to create a market in India. And these are things that MedPro could not have done without us. They could not have done it. It's absolutely impossible to just come into the Indian market and do these things.
Let me ask you a question. I assume these are actual out-of-pocket dollars.
Yes.
So I can represent to them that, again, really going the other way, if there were a settlement, maybe subject to appropriate confidentiality, because I know these are private expenditures, could you verify that actually $500,000 or so had been spent in one way or another on the development or marketing of these oximeters?
Well, there's a significant percentage of those expenditures that can be verified with receipts. But they know damn well how the game is played, and they know that there are some expenses, if you will, that generate goodwill when you're trying to dive into a market, especially a foreign market, where those aren't things that lend themselves to receipts.
Okay, fair enough. I think if we could verify a significant percentage of that, they would understand that the rest of the money had to be spent as well.
I have some good news and some bad news. Well, let me just say it is very common, you know this, for someone on the defense side to start off relatively low. So, but I want you to understand that I think what they're trying to do with this number is signal that a certain range that they're going to be in. Let me just come out with it, right? What they've offered is $60,000.
What? This is not worth my time. I am asking for millions of dollars and they are talking $60,000. What kind of offer is that?
I think that offer is what I would call a start.
I would call it an insult, and I'm feeling insulted by it.
Well,
This is not what we expected.
No.
I think that is bad faith. I do not understand.
In view of what you saw this relationship as being, and perhaps hopes coming into today, I understand how that could be a disappointment or viewed as an insult. And I understand how it could make you feel, oh, we're never going to get there.
It seems we are wasting our time.
Well, I don't want to waste our time. Let me just say it depends on what strategy you're using. If this offer is intended to say I'm at 60 and I'm only going to 75, then it's maybe not a great offer. If it's just intended as a start and a bit of a response to 1.6 million, then it's a strategy. It's a strategic offer. I may or might not like that strategy, but I understand that strategy.
I do not find it helpful because I fly so far, so many hours I spend to come here to spend this time, and so much money we are talking, and they're saying $60,000.
It seems low.
It doesn't seem low. It is low.
It is low. Or then what? Well, can I ask a question? What would you have anticipated they would start with?
Well, I would have thought at least several $100,000 would be a much more realistic assessment from their perspective. I do understand that this is a strategic situation, but I share my client's outrage.
Let me make a suggestion. Remember I said at the beginning that failure in this process is if a settlement would have been possible, you know, if there was some omniscience, something in the room that knew that, and we missed it. Remember that? So what I'd like to be able to do is to see, I think what we want to be able to see is, even if we're not happy, if it makes you feel angry that this is what they did, insulted that this is what they did, why, if there's a settlement is possible, why let that feeling get in the way? So,
But how will we know this?
well, let's see how they move with the numbers. I think that's how we'll know it. That would be my suggestion. You wouldn't want to fly all the way here, get an offer, say I'm insulted, leave, and find out later that actually they would have come up to a range that would have been okay. Wouldn't that be a shame?
We're here now. We'll go forward for today.
If we can put aside for just a moment the legal issues, I'd like to understand the non-legal aspect of this, because part of what they offered, even as they were, I know, terminating the contract, was an unexclusive arrangement, and I know why that is very suboptimal from your perspective. At the same time, I'm wondering what Mumbai could do with an unexclusive, whether it has any value at all. So I'm wondering, how many probes are you selling now? Now you don't have that, but you are supplying replacement probes, it sounds like.
non-exclusive have any value to us or to them?
Well, I suspect it has some value, or I could argue that it has some value to them, but maybe it also has some value to you, although not the kind of value that an exclusive relationship had. But I'm wondering, right now you have neither one, really, because you're, I gather, getting probes from third-party sources and then
Yes.
supplying them?
Yeah, we are getting probes still. I mean, that's a different issue. There's not quite the quality that we used to get. But you're asking me about replacements now, like not under the
Yeah.
agreement, how much
Sounds
now?
like you're basically using what I might call generic suppliers.
Right, right. I mean, we're probably doing about 600, I'd say.
Okay.
600 over the past year.
And what is the margin on those, roughly? What would you expect to make per probe sale?
Well, if we get the most favored nation, then I think we could make about $150 on each sale.
Okay. So if you're talking anything like $1,500 a year at 150 gross margin, that's a profit of, even assuming some distribution costs, of over $200,000 a year.
Yeah.
Which is not insignificant. I know it isn't what you hoped for, but still. On oximeters, have competitors started selling actually MedPro oximeters in your part of India?
Well, actually, not much. I mean, we shut down one company, the Bangalore Hospital Supply
Right,
Company. So
right.
that, actually, they're not selling. There's a couple, there maybe two other small companies they're selling, but they're not, the product is a little bit less sophisticated than what we're able to sell from MedPro. So actually, the competition has not been quite as bad as we
Okay.
had feared.
If we were able to rearrange a guaranteed source of supply of MedPro oximeters, again at favorable prices, that would have to be negotiated and guaranteed in a contract, a year out, what would you think your volume might be on oximeter sales?
Well, I mean, it won't be anything like it was because we had the exclusive
Understood.
agreement, but I suppose it could be as much as 50 or 60%.
So you just multiply that out, you're looking at a slightly over $100,000 a year in gross profit on the oximeter sales, plus over 200 on the probes, as you've estimated. Again, assuming a guaranteed source and the right pricing, that's over 300,000 a year from even a non-exclusive. I know it's not what you were looking for and not what you had under the old contract, but that's a pretty significant amount of money per year.
Yeah, that's true. That's true. But I mean, while that's true, I think in order for me to think about these things, I need to know what is MedPro's plan.
Yep.
What are they going to do in the future? And I think as you and Chris were discussing, I think, we need to be very clear about under what terms can the agreement be terminated. Because I don't want this to happen again.
I've got to make MedPro understand that this would be a profitable and sensible thing for them to do as well, to be able to have Mumbai partners representing them again in southern India.
Dwight, this is all a very nice proposal, and there's some value to us in having a non-exclusive arrangement, but you have to remember we started with an exclusive arrangement. So in order for this to make any sense for us, we're losing something there. We have to gain something on the money side. We have to be accurately compensated for the losses. And there are valid legal claims here which can be shown and demonstrated which represent those losses.
Yes, I've heard that very clearly, and I understand there are essentially two sides to this case. And for you, the most important one at this point, given what's happened to the relationship, is the monetary claims. I'm trying to understand the other part simply because it may become the gap filler that once we really address the monetary side, sort of puts the whole thing together. But I understand it's only one part of the puzzle, not the puzzle itself.
What I thought I would do is look at the litigation piece with you. Because I've been talking with them in the other room about that a lot
Okay.
as well. And so I'd like to talk about it with you and see. I understand that you have a theory of damages, a claim which says, this was going to be a long-term relationship. It's not only governed by that piece of paper, and you made a projection of what your sales would have been, particularly not involving Chattawa, under conditions
Yes.
that you would have anticipated. And that is the thinking that informed your $1.6 million position. I want to look at the damages that would flow from your other legal theories. Okay, so let's just look at the contract piece just for the moment. MedPro would point to the sales figures, and we wouldn't be able to show any involvement by Cho, so it would just be from Chattawa and stuff. And they would say, looks like there was cause for termination, and looks like this. So the worst case is nothing. Right?
Correct.
And you're just saying you don't think that's going to happen.
No.
Okay, that's fine. But when I say worst, it's worst. But then you're saying that the 90 days is your most realistic worst.
I think so.
Okay, well,
yes.
let's talk about what that would be. Assume for the moment that you had a situation where the court said, well, no real cause or not sufficient cause invoked, and so under this contract they had a 90-day termination provision. What would the damage, what would you be owed?
The way we would look at it is that if we would have a reasonable expectation of about $33,000 a month profit
And you're getting that from the year with
from
the
our prior year sales
800,
figures of $800,000,
and you get gross profits out of that of 400-ish.
$400,000. That's correct.
And if you divided this division,
That's $33,000
33
a month.
Okay.
And if we had 3 months on the contract, that would be approximately $100,000, and that's just on the contract termination
And
claim.
you'd cover that. One of the ways they came up with the 60 was by saying, well, they don't like using the 800 because it was the best year. They
Well-
understood not using the 400 because of the Chattawa problem. So they actually looked back to the 500 year, by which time, which was the year before the 8, by which time you'd been in the market for a little bit. If you use the 500 figure, that's 250 gross profit, 20
Right.
a month. So that's 20 a month.
200.
That's where they came up with
Right.
60. Okay. Do they have? I mean, right now, it's it's about about a year from the time that you got that letter. It's could they send you a letter tomorrow saying now we're going to do it right and we're terminating? Well, we're deciding to not renew as of the September 1st.
Right.
If they did that, what would your
Well, we'd have 14 months then, 14 months of damages.
Okay, so if you had 14 months of damages, if we do times 33, that's
That's 460,000.
460. And if it was by 20,
We
that
use
math
their
is much
figure,
easier.
20,000,
That's
that's
280.
280,000.
Okay, so let me ask. I know if a court just limited you to the contract, to the paper. I know you don't like that part, but if they did, if an American court did that, is the 460 your best case
On the contract?
on the contract?
I think it is.
And there's a range that goes between 60.
I'm understanding little.
Okay, there's a range then. If it's 90 days, it could be as low as 60 to 100. If it's 14 months, 280 to 460. So there's a range between 60 and 460. If the court just said, and zero, we forgot the zero, but if a court said, no, the contract, then I just want to make sure that we're figuring the numbers the same way.
I think we are.
Okay, all right, that's helpful. And I do get that that's not what it was about from
No,
your
it's
perspective.
not making me very happy to see that.
Well, that's why I actually want to make sure you agree that that would be reality if a court only went to the contract.
Only looked at the contract claim and then looked at the profitability differently than we
Right.
would be
Okay.
arguing.
All right.
So there's a lot of variables in there.
Yes, but we were thinking profits over a long time, no?
Right.
Yes.
Right. And those are the things that get you into the $1 million range. Legal issues aside, just for a second, can you tell me how has the probe and oximeter business been in India over the last, since the since you terminated Mumbai?
Well, our view is that Mumbai has actually really sabotaged the sales strategy that we had for India. And it was, it's not just that the sales have not been zooming, but that there's been active misconduct.
So there is a
With
legal
it-
issue there.
Yeah, and that
Okay.
has obviously affected, it has had an impact on the kinds of sales we're experiencing.
Right, I mean, what they've done is they stocked up, basically, knowing that they were going to get cut off for not having enough sales. Where they could make sales, they made sales. And now we can't go in there and sell our product to anybody because they're all stocked up.
Let me ask, I know that when you terminated their contract, or maybe not too long after that, when you terminated Mumbai's contract, you did offer them the opportunity to be a non-exclusive.
Yeah.
But I understand that that hasn't happened because of whatever, that hasn't happened.
They turned around and
If we could undo the unpleasantness, assume they didn't sue you, okay? And you offered them a non-exclusive and they said, we're not happy, but okay. Would they be able to make sales here, to continue to make sales the way they were before?
the way they were before, I guess. The fundamental problem is that they weren't making the types of sales we were expecting.
I have another business question for you. How have you set up your business in other countries? In other words, is it typical? I know here you started with an exclusive, you've moved to non-exclusive, or wanted to move to non-exclusive. How have you done it? How have you done the arrangements in other countries?
Usually we've done it non-exclusive. That's the best way to do it.
How does it work? What do you have to do when you're going to a country that way?
Okay, there are a number of things that we have to accomplish. We have to make sure that people are getting trained on how to use this. So we may go to medical schools. We may have somebody go in and give demonstrations how the product works, sales pitches essentially on the product. But there are sales pitches that are aimed at reassuring them about the safety of the product so that we get approval to have the product used by hospitals. And then obviously it transitions into, once we get the approvals, into sales. Can we get people to buy the product?
Right.
At that stage, you really have to have either the non-exclusive people or our company putting in some energy, some money, some legwork. And if it's decentralized, it's a lot harder. You got to do all these fractured sort of pitches.
So, depending on how centralized or decentralized, either way, it's a labor-intensive process. You have to, if it's a different country, you have to send people over there. You have to house them. You have to get people over there. You have to do the trainings on the before they purchase, then after they purchase. The reason I ask actually is Mumbai says that they spent, because it wasn't a non-exclusive, that this was their job to do.
Yes.
They spent somewhere on the order of $500,000 doing that work. I don't know if they've covered all of India yet, but does that sound, I mean, using that as a measure, does that sound outlandish to you?
No, that they could have spent $500,000. Yes.
Okay.
But they are in profit mode now.
yeah.
I mean, just to be clear,
Right.
their sales to date with the slow growth that we are so troubled by has already put them into profit.
Above the,
Yes.
they've
That's my
expended.
They should have gotten a lot more. If they put in $500,000, they should have gotten a lot more out of it than they've gotten. But yes, I can believe they put in $500,000.
Okay, all right. One way to think about money that you would pay to Mumbai is not as, I'm settling a legal claim, I did something wrong, that's is to say, well, you could think of it as, because they were an exclusive, it was in their interest to be the ones that spent the $500,000 because they were going to reap all the upside later. Now we're going back and saying, well, it's going to be a non-exclusive, and if you'd done that from the beginning, you would have had to bear that $500,000 expense.
Are you suggesting that we pay them $500,000?
No,
Okay, good.
I don't think that's going to be necessary.
Okay.
But here's what I am suggesting, just a way to think about it, is that if you did, or less than that, whatever amount you pay
I
that's
see what
less
you're
than
saying, right.
that, you could think of it as,
What
a
we would have paid.
reimbursement. You would have had to pay it.
Right.
Someone's got to pay it. You could think of it as a reimbursement for having to put in that upfront investment, because now the folks who are the non-exclusive distributors after that benefit
I understand what you're saying. I appreciate, that we could recast it as kind of a research development front end
Yeah, that's what I'm
cost.
thinking.
But the bottom line is it's way too big a number.
Thank you for waiting. It's taken a little while because I tried to convey to Mumbai's some of the issues that you raised. And I do have a new offer from them. They were at $975. They've come down to $875. Well,
It's nowhere near realistic. That's not a significant move.
well, it is $100,000. I understand that they're not yet in the range in which you could seriously consider a settlement, but my experience is this is the process. We're a good deal away from the 1.6 million that they were before, and I think they understand that this isn't going to solve the problem. And yet, it's part of a process, so I do need another number from you, I think, to respond to them, so that then I can go back to them and suggest that some more movement is needed.
I think we could go to 140. That's where we're comfortable, given the circumstances.
Okay, so it sounds like you're thinking that the most likely exposure, if there were any, would be for the 90-day termination, which would be on the order, and as you computed, of more like 60 to 75,000. Some concern about maybe a 14-month exposure, and as you average it, that's how I would explain it to them.
Yeah, that's our reading of the contract. That's about where we're exposed.
The mediator suggested that MedPro make its next offer $160,000 rather than $140,000. He stressed that a move to $140,000 would represent only a $20,000 increase from MedPro's last offer and might discourage Mumbai from compromising further. MedPro resisted the suggestion, and the mediator took a different approach.
Where would they have to go for you to be comfortable going to 160? I know it's not 875, but the question is, where would they have to be? What kind of signal would they have to give you for you to say, okay, we can go there now? It's not, doesn't mean we're going to where you are, but at least we're in the right range.
Not 875. Let me just.
Yeah, it's okay.
I would say if they came in at 250,
Okay.
somewhere in that range, we could reframe this.
This would give you a place from which the further compromises could come that might get this to something that you could realistically, essentially explain to the company.
Yeah, that could get us to be able to counter with 160, but not 2. We're not going to 2.
Okay.
Just
No, I understand.
don't want to.
So, I'm not sure whether I would want to explain this to them or not. I don't know if they're ready to hear a number like that, but if and when they are, would it be okay for me to explain that that's the range in which you think then the future bargaining has to happen, as opposed to where we are now?
I think we're
Okay.
comfortable sharing that.
Okay. So, I've talked to them. They see, I think what's happening is they're seeing their primary exposure under the contract as being the 90-day termination. It could be, they say, 14 months, but they think more likely about 90 days. And they've got the lower profit figure per month than you compute. So they've gone to 140 from where they were before as their next move.
140.
Well, that's where they are now.
Do they understand this is a good faith process, Dwight?
Yeah, I mean, this is ridiculous. We moved down $100,000 and they've moved up $20,000. It's completely insane.
I think the problem is that they're seeing your 875 as being considerably higher than you could recover under the contract, even under a 14-month termination.
In our view, there's a much more realistic number where they should be at this point.
Where do you think they should be?
I would say at least 400,000.
If they were at 400 with a non-exclusive arrangement, continuing in the future with appropriate guarantees, where would you be? If I could get them to 400, just for my private information, this isn't, just for me to know.
Give me 1 second, please.
Sure.
Yes. Yeah. I think we would be at about 650.
Okay. All right, well, that gives me a sense of what the range needs to be from Mumbai's perspective.
Which, by the way, is a number that is a huge concession from where we started and a huge concession from where we started this conversation with.
If I think it's the right moment, would it be permissible for me to indicate that, from your perspective, that's the range in which this bargaining should be happening?
If you're
Well,
going to
this would,
throw those numbers out, it has to be with the understanding that the 400 is, we're talking about bottom end of a range, and where we're really realistically at is closer to the 650.
sure. I guess what I would say to them is that you've sent the message that in order to get you to 650, they'd have to be at 400, and you haven't seen it, and therefore you're not anywhere near there.
That's a much better way of conveying the message.
Okay. Well, I'll try to be very clear about it.
Have you folks ever heard of something called decision analysis?
Yes.
No.
I don't know that.
Okay, but I think I remember from your background that you had some math.
I know very good math.
Very good math. Well, I don't even need very good math here. I just need arithmetic. Let me tell you what the logic is and how it works.
The mediator gave a simple explanation of decision analysis, then turned to how the process could be applied to help parties make decisions about legal cases.
And the idea is to say, well, most of us like to think that we take what's going to happen, we discount it for the risk to figure out whether we should go one way or another. Is that making any sense
So
to
you're
you?
saying look at probability.
Yeah, that really is what I'm saying. I'm not, by the way, saying that you have to settle a case on the numbers that come out of this, but it's a way of thinking about it. In a way, it's if you were a computer, which you are not a computer, this is how a computer might go about looking at this. Okay? If we were to finish discovery, what would happen next? There would be motions. What are the motions?
Probably a summary judgment.
Okay, so they're going to file a motion for summary judgment. You know what that is.
She has explained
Yeah,
to
we
me.
talked about it.
Okay, and my sense is he would file a motion for summary judgment on the longer term part of this.
Correct.
Not on the
Yes,
written contract
right.
part. Okay, so the first thing that would happen is the summary, before trial, the summary judgment motion would be heard on the issue of the longer term, I'm calling it, right? The larger damages piece. And summary judgment could either be granted on that piece or denied, right?
Right,
Right, okay. They could find cause, and if they find cause, you're done,
right.
okay? No cause. If they find no cause, then what?
Then we would look at the other grounds for escaping from the other escape clauses from the contract, the 90-day termination.
Well, then they could find yes, but it was a 90-day termination.
Correct.
What I'm interested in knowing from you is what percentage risk you would put on these things. So my first question is, what do you think are the chances that you get by summary judgment, or that they win summary judgment?
On the future.
Just on the future
issue,
part,
yeah.
yeah. Mhm.
We've talked about this, Shalini and I have talked about this, and I think there's a fairly high likelihood that summary judgment on that issue could be granted.
Would you put it at 90%?
Reluctantly.
It
I'm
is this
asking.
high,
Yeah.
90% high.
Okay.
Yeah.
All right. Well, let's just see. We can, one of the things about this is that we can always fiddle with it. Okay. Notice how these two things have to add up to 100, right? Because those are the two things that can happen. Win, granted, not granted. Okay, so now what do you think are the chances that they find cause?
I think realistically very low.
There's no cause.
10% at most.
Well, their argument is that the sales went down. They didn't make the sales go down, and that was cause, and they kind of sort of talked about it in the letter. I don't think so.
No. I think variable sales in a situation that young is predictable, and I do
No
not
cause.
believe that's cause.
And besides, the original contract didn't set specific
No,
sales
it did
dates.
not,
Okay.
nor did the letter allegedly terminating the contract allege cause or describe what the cause was.
Okay, so what percentage would we put on that one?
I would say not more than 10%.
Okay, what's good for the goose, right? Okay, so 10%, so no cause, but let's look at the 90-14. What do you think are the chances that they cap the damages at the 90-day termination versus the chances that they keep it at the they take it out to the 14 months?
I think the 14 months is a more realistic likelihood, and I would put it at more than 50%.
Would you do 60-40?
Probably, yes.
Okay. Okay, so the way this would work, if I had a computer, you could flick a button, like TurboTax, and you could do it. But the way you would figure this out is the way you would do this then is you'd roll it back, you'd discount it back, and you'd say, well, 460 times 60% is 277. 100 times 40%, that's an easy one, is 40, right? We would add those two together. I can explain why in a sec. Well, what you would do is you say, well, there's a 40% chance of getting $100,000, that's worth $40,000. There's a 60% chance of getting 460. We said that was 277. You would add those two together because together it's sort of like a blended average. It's like a weighted average of the things that could happen.
These numbers are looking very bad.
Very bad. Yeah, I hear you on that.
I did not know I was coming today for math. I thought I'm coming for mediation.
Well, let me just say this. If what this is suggesting is if you leave the mediation and you go forward to trial, these are the way that your lawyer would look at the risks and what might happen at trial.
It's very bad.
Well, if it's very bad, then that's actually why I would suggest that we look at what we can get on the table here.
I have to talk to my lawyer about this because I am not agreeing with these numbers.
You're not agreeing with the percentages that your lawyer put on them, or you just don't like the way they come out?
I don't like the way it's coming out.
Yeah.
I very much trust my lawyer.
Yeah. Well, I mean, I have to say that I don't blame you for not liking it. The real problem is that
yes.
That's the problem.
Yes, because I was thinking it's something very different.
Yes.
And I was expecting something very different.
I hear you on that.
And this is very disappointing.
Well, and the other piece of it, which I hate to add, insult to injury, is that you realize that this doesn't even include the lawyer's fees, because in the American system, you pay your own lawyer's fees. So even if you won, say, $460,000, you have to back out of that. I mean, you have to pay something to get that. So it's actually worse than this if you were to go forward that way, which is why, look,
it cannot be this bad. Why they would offer if it's this bad?
You really want to know?
Yes, I want to know.
Okay. Well, I don't know what's going on in their heads. People have all sorts of business reasons for wanting to settle cases. Sometimes they don't want to have their executives tied up. Sometimes they actually feel bad. I mean, look, I think the argument that you made that you had invested money in marketing and things that they would have otherwise had to do themselves, I think that had some power with them.
I explored a couple of possibilities with them. One is what we might call range bargaining. The idea being, could we agree on a range in which the bargaining would happen? I asked, if you move to a certain place, where would they move? And obviously you would have to agree to move there, and they would have to agree, but what they came up with was that if you were willing to go to 400, they would be willing to go to 650. And I didn't indicate you were willing to do that, but they were not happy, let's say, with the idea that they'd gone down as they saw it 450 and you'd come up 20 to 140. Well, I understand, but that was the context.
It seems to me that they're just not getting it in terms of a realistic appraisal of the case.
Yeah.
And in terms of the range bargaining of 250 and higher, I just don't want to go there. It just seems to me clear what will happen from that point.
Okay. Well, I said I would ask, but I didn't give them any assurance that you would agree, and there we are. There are various possibilities here. One is you could make another offer. At some point, I suppose, I could try to give some predictions about my estimate of what a jury might do with some of this. I think it's a little early for that, because it tends to freeze the bargaining. There are other things that could be done, but they really involve me taking much more of a role in this than I'd like to, as long as we're still moving somewhere. But there is the question of where really we're moving to. I think there's some strategic maneuvering going on. Maybe a little bit on your side because you have to, and maybe on their side. One way of cutting through that sometimes is what we call confidential listener. The idea being this: I would ask you and them confidentially for your, what I'll call your next to last number, the point at 5 or 6 p.m., not your final offer, but the one just before your final offer when you'd say that's it. Having gotten them, I would bring in the two lawyers and I would tell them in the same time, in the same voice, a verbal statement of how far apart you really are. I wouldn't give you a number because then you could just calculate what their number was and they could calculate yours. And that would give you some sense of what the real gap is. So you'd both have to agree to do that. It doesn't mean you're committing to any specific new offer, but it gives you some new information.
You won't share the amount of the
No,
gap, just to
not without your-
characterize it as small, medium, large, extra large?
That kind of thing. I will not without your assent. And I wouldn't disclose theirs to you without their assent.
Well, I think there's value in knowing how truly
Okay.
far apart we are.
Mumbai agreed to the confidential listener process and told the mediator that its next to last number was $550,000. MedPro gave a number of $170,000. The mediator then met with both lawyers.
I've gotten from both of you a number, and let me say where things are, and it's not either one's final number, so you're going to have to make some adjustments in your mentally for that. There is a significant difference between you. It's going to cost as much or more, maybe a lot more, to litigate this case. So given the range of the gap, and given the cost of litigating, we're talking, as far as I can see, of taking depositions in India, reviewing 5 years worth of business transactions on both sides. For all I know, a trip to China, let's hope not. And all the rest of the things that go into litigation, including, I've been told, motions are going to be filed inevitably and have to be dealt with. I think it's worth continuing to work on this because you're in the range where it really makes sense to settle. But I can't tell you you're 25,000 apart and, I can just suggest splitting the difference. We have some work to do. Okay?
How do we go about doing that work?
Well, I think there are two options. One is I'm under ground rules under which I can't reveal either of your numbers to the other one, and I'm not going to. If you both said that you wanted to reveal your number or authorize me to on condition that the other one did too, I could do that. Or I think at this point the ball is in MedPro's court in the sense that the last offer came from Mumbai, and so I would meet with you and with Pat and see what kind of response you made because you're at 140 as of now. Those are really the two options, and should think about them for a moment. Maybe if you want to talk to your client, because I know you have sophisticated clients, and we can do either one of those things.
Well, I've spoken with my client about it. We would be willing to disclose the figure that we have given you as our next to last number, with the understanding that it's our next to last
Well,
and not that far away from our last.
Okay, I heard that part. Well, do you want to talk with Shalini?
I will. I had certainly
Okay.
hoped that MedPro would be willing to make another offer. But
Well,
if what you're
this
saying
doesn't
is...
this doesn't exclude another offer. This is about how much information you have other than or in addition to another offer. Well, Chris, while Ragini is out of the room, we're approaching, I sense, a real, if not an impasse, at least a tough situation between 750 and 150. I wonder if it would be useful for me to give you and Ragini some predictions of what might happen on this contract case in the U.S. courts. You don't have to agree with me, but just I do have some views about it, and
I think that would be very helpful, especially for Ms. Gandhi to hear.
okay. I was talking with Chris while we were out, and I was thinking it might be helpful for me to give a prediction, if you will, of what seems likely to happen based on my experience with the American courts if this case were tried. And we don't know in any one situation what would happen, but if it were tried hypothetically 10 times, what would be the average outcome? I don't know whether that is something that would be useful, or is that...
I think it would be.
Okay. Well, I think there are various theories here, and you've heard them articulated. One is that the contract was terminated for cause. And another is that essentially they gave 90 days notice to the next September 1st, in which case there would be 90 days which you'd be entitled to recover for profits, and then the contract would terminate. Another theory is that it hasn't terminated at all. It just was ineffective, the termination notice they gave. And Chris, if that were true, is there anything that would prevent them from sending a termination notice next week for this coming September 1st?
You know, Dwight, probably not. I mean, we'd obviously argue that that the detailed oral discussions and representations that were
Yeah.
made should trump the language of the written contract, which is one of the reasons why Ms. Gandhi is so upset, because they had those conversations.
Yep.
It was sort of the handshake to the company meant more than what was written on that piece of paper. That being said, I think the likelihood of prevailing on that legal theory is very low.
Yeah. There seem to be three basic possibilities. One being the termination for cause, another being, I'll call, the 90-day termination, and the other being the 14-month termination. And I had said no more than a 10% chance that a court would find termination for cause, meaning a 90% chance they'd find they didn't have cause to terminate you. And of the 90%, about let's say a 60% chance of the 90-day termination being ruled effective, and about a 30% chance that it wasn't effective, in which case they'd have to give you full 14 months. If it's termination for cause, there is no recovery. If there is a 90-day termination and you are earning, by your calculation, over $30,000 in profits per month, that's $100,000. If it's 14 months times over $30,000 a month, that comes out to about $460,000. If there's a 60% chance that the 90-day termination would be effective, and it's worth $100,000 as a recovery, that's worth $60,000. If there's about a 30% chance that you would get the full 14 months, 30% of $460,000 is about $140,000. The average verdict would be about $200,000. And that's assuming your profits are accepted by the court. I think that's more likely than not, but it's not certain. So on average, the trial value might be in the $150,000 to $200,000 range under the American court system.
No guarantees. It's just sort of a risk assessment formula based on outcome possibilities.
Yeah, but I mean, this is, well, I don't know much about the American court system, but it's very upsetting because, I mean, actually, the real contract was not this 90-day, 14-month, it was a long-term contract. That
Right.
was the contract. And MedPro has done enough business in India and Asia that they understand that conversation was the contract. They understand that.
Yep.
They know that. And the fact that there's no way to get that into the American courts, I find it very upsetting.
There's also the issue of cost. I don't know what it will cost even approximately to litigate this case. I don't know if you've thought about that, Chris.
Well, I have a good understanding of what their attorneys charge, and if we don't get some major concessions, then we're not going to back down, and I think they're going to have to do a lot of work. So I'm guessing it would cost them about $750,000 to litigate this case.
Well, I'm not disagreeing with you, and you have an advantage because you have an efficient, very good lawyer who has much lower overhead than the defense does. It's still, you're going to have to take depositions in India, maybe in China. There's all the emails to go through. What do you think the cost is from your side to litigate it?
Probably $300,000.
Okay. Well, that seems realistic. The problem is then that it pretty well wipes out any recovery.
But don't you also need to take a look at their risk assessment with litigation costs as well?
Yes, and I think that's why they're offering as much as they are, and why I believe that we can get them to go higher, and I believe we can even get the guaranteed, favorable, non-exclusive. in light of this, I think what I need is something, I'd like you to talk, but a move that reflects your understanding of what is likely to happen if we can't get this resolved today and you have to go through litigation, and a signal that will bring them forward into a range that we can settle this. So I'll leave you, do your best, and let's see what happens. Okay?
Let me report to you on progress, okay? Any deal that we've been talking about for a long time included a non-exclusive arrangement for you to continue to sell oximeters and probes. Okay. So they were at 150 with that non-exclusive arrangement. I came back to you and you said that's not enough. You were at 500, right? With the non-exclusive.
Right.
I went back to them and what they said was they'll go up to 165 with the non-exclusive. But if they're going to go higher than that, they'll take the non-exclusive off the table.
So right now we have a door A or a door B from them. Is that right?
That would be a way of looking at it. They're saying, yes, they would take the non-exclusive part of it off the table if you're pushing them that hard on the cash, yeah.
But I mean, that hurts them as well. You know, if they're not going to be selling in India anymore, I mean, I think that they're just doing this out of spite. It's not really negotiation at this point.
For them, you know, if they don't give you the non-exclusive, they don't have too many people in India selling the product. So it seems strange, right? That why would a business person say no?
Well, also,
Yeah.
they've benefited tremendously from the goodwill that Ms. Gandhi has generated
Right.
in the relevant business community.
I understand that. And they are business people, and you would think that business people would be rational and want to go with a deal that has their best agents, really.
Exactly.
Okay, so here's the problem. They're getting frustrated, and they are feeling pushed, and they are just saying at some point it's over some point in money. At this point right now, they're saying it's 165. They just don't want to do it anymore. So whether it's spite, so let me just say, what I worry about is any deal that you do is better for you with the non-exclusive than it is without it. And so I'm communicating that they're getting antsy and they may pull that off the table. And if you want that in the deal, which I think you do, it was worth, we calculated, it was worth somewhere on the order of $300,000 a year to you. And better to do now than 5 years from now, right? Because the other distributors wouldn't have gotten a toehold. Then I'm just suggesting that you'll need to come way down on the cash component if you want to keep that in the deal. So why don't you think about it? You know, think about something that is, I don't know, something with a 2 in front of it. It could be a high 2, plus the non-exclusive. Why don't you think about it? I'm just communicating that it's the tensions are running high in the other room, and I feel that one coming off the table.
Well, you can also report to the other room the tensions are running pretty high right here.
I will do that. I have actually been doing that. Assume that you could reach a deal that had a 2 in front of it on cash plus the non-exclusive. Is that better? Is it not what you hoped for? Even if it's frustrating, even if it seems unfair, is it better for you than pursuing the other option, which is to go to trial? That's the question I'll leave you with. So think about it, and then let's pick it up. Okay, I'll give you a couple minutes if
Thank
that would
you.
help. Okay?
Well, I communicated your move and that to do that, the non-exclusive was gone. Their reaction is really, that's not very much of a monetary move, and the non-exclusive disappearing, they really weren't willing to make a counteroffer. So I think that leaves us with some options. One option is you could make another offer. I can imagine your reluctance on that, but that is an option. Another option is to restore the non-exclusive, because that does have value, and you've communicated to them that it isn't a sure thing by any means, given what's happened. Another option is what I'll call a mediator proposal, and I'd like to explain that in a second. And the fourth option, I guess, is to wait and see if they will blink, so to speak. I'm a little concerned, given what I've seen of Ms. Shah, that she may call an end to the day if we really are with that. So the mediator proposal is this. I would make a proposal. It would be somewhere between where the two parties are. It would probably have a non-exclusive in it, because that's very important to them, but it would not be at the kind of numbers they're seeking. I would ask you to tell me privately, could you agree to it on the assumption that they had agreed to it? And I would ask them the same question. And you'd each tell me privately. They would never know whether you ever were willing to agree to the proposal unless they agreed to it as well. Similarly, if you said no, you'd never find out if they had ever said yes. So each side's bargaining position is protected unless you have a deal. You either have a deal, or you're right where you are now, and they are where they are now. It's really based on what I think both sides could accept to reach a deal. I don't mean this as a judgment about what's right or wrong, but what is the minimum that each side could accept in order to get to a resolution. And I find that a good 2/3 of the time or more it works. No guarantees, but that would be an option.
I don't think we're inclined to do that, no.
Okay. So I guess the question then is, what would you like to do? Any guidance you can give me about what we should do from this point on would be helpful.
I think we probably need to talk.
Okay.
But
Okay. And really anything that we can come up with, as long as I can get them to agree to the process, I'm perfectly willing to try.
Okay.
Okay.
We'll
So
try
you
to
let
be
me
quick.
know. Okay. So I don't know if you've had a chance to think about it and reached a conclusion.
We have, and we're not going to be able to do that. When we talked just now, we're pretty firm that we're not going to go past 190. We're just not able to go past that.
Okay. Well, would the 190, if necessary, include a non-exclusive, so that I could at least offer it to them, even if they're not going to see any number beginning with 2, much less 3 or whatever?
Yes, but that we're not comfortable going any higher.
Okay. Could I indicate that to them? That you're not willing to go to any number that begins with 2, that if it would settle this, you could go to 190 with the non-exclusive, but not to 2 or any number higher than that.
That's
Okay. Well, it will be a very hard sell. I don't know if it'll be successful, but I'll try, and we'll see what their answer will be.
When I was in this room the last time, I explained what a mediator's proposal is. And I asked you, you remember, to say, will you go along with the idea of a mediator's proposal? You said yes. I asked the same question of the other folks. They said yes to doing the idea of it. My mediator's proposal was at 240, and you folks did say yes to that. But what I need to, unfortunately, to tell you now is that they rejected it. So they said no to the 240. They don't know, however, that you said yes. So we're a little stuck. Technically, everybody is at where their numbers were before. And I'd hate to come back to people after a mediator's proposal. But I guess my question to you is, look, if I could get them to 225, could you folks swallow that?
Well, it's.
I didn't say it was fair. I'm just asking.
It's still below our bottom line, but I assume we're still talking about non-exclusive,
Yep.
and most favored status.
Yes.
I think we could think about it.
Okay. So, why don't I poke around with them a little bit and see? I know they've said no to the 240, and why don't I poke around and see if I think I could get them there before I start floating out more numbers. Okay? So I'm not gonna. As I'm hearing you, you'd think about it if it would do it. I'm going to poke with them, see if I could get them to something like that. And if so, let people consider it. Because I don't want to come back and say, oops, I didn't get that either. It's the end of a long day. And for everybody. Here's what I want to suggest. I want to ask you to make a last and final offer. The good news about that is that I'm never coming back to you for more. I hereby pledge, Scout's honor. And we're now in a range, by the way, where I can say to you, oh, good heavens, you should really take this because the fees involved were so close. Is it 10, 15, 20 grand more than maybe somewhere it should be? Maybe. But it'll get it, if it'll get it done, is it worth it to you to do it as opposed to spending any more of your time worrying about this? This is where the range, and I can make that same speech to them, but I'm going to suggest that, I will. I'm going to suggest that I'm going to ask you for a last and final number. That's one that I think I can get them to do. I'm not asking you for any more. And that amount is $225. I know it's more, but are we digging in just to dig in, or is it worth it? If it's worth it for you to pay where you are now, is it also worth it to pay $225
With a non-exclusive.
with the non-exclusive, which is to your benefit? Stop paying your lawyer. Move on.
Can we make it 210? I mean, with all these same variables, is it really worth it? Let them take a little nibble out, and how about 210?
Here's my thinking. Okay, you're actually, you're a business guy, and but people make decisions about numbers based on emotions and sticking points and all that, and I am getting a lot of that from the other side. So here's my concern with 210. 210 is going to sound to them like barely over 200. Okay.
That's how it sounds to me.
I know. Yeah. Well, but so I could do 220 by saying, because I suspect if I can get them to 225, I should be able to get them to 220. But at this point, it's not worth. If I could have 220, I can sell it to them as not just being barely 200.
215. Does 215 have that sound?
Well, here's the issue. Okay, if you say 215 to me, I might have to break my promise and come back to beg for 200. You don't want that, right? You don't want that. No. So I'm saying, if you just give me 220, then I'll keep my promise.
Let's do it.
Okay. It's not worth your time, your company's trouble to keep this going. So,
Absolutely.
Good. I appreciate that. I hereby pledge I'm not coming back to ask you for
to
more. I'll either come back and say we have a deal, and I will now spend, I bet you, a lot of time with them trying to see if I can sell that number as your last and final. I really am hearing from you that it is your last and final, and I will respect that. Okay.
So, I talked to them, and with the idea that, and not necessarily telling them that you could accept 225, I saw what could be done. And at first, the reaction I get was that they would not go above 200. That just seemed to be a mental barrier for them, psychological. I sometimes find that if I tell people that something will be the last and final, the last time I come to them, I can actually get them to go beyond where they said they would. So I decided to try that. And we went back and forth between 225, and in the end, by telling them that I would not ask them for any more, I eventually got them to say they would go to 220. So they will go to 220, but that was with me telling them I couldn't say that you'd accept that. I don't know that you will. But it was simply telling them, all right, you've got to go that far, but if you will, I will ask Mumbai whether they would accept that with the non-exclusive and with the most favored nation guarantee, so that you wouldn't be under the kind of contract you've been in the past and the uncertainty. They've put it on the table.
So this is a firm offer.
That they will pay. So yes, that's the offer. And I know it's nowhere what appears fair, but in terms of what we can get today and what the American legal system can provide and certainty, so you can put this behind you, I think it has a lot to recommend it. And I'd ask you to just think about it. It's your decision.
We've had some conversations about this, and I think given the need for closure, we've come a long way. We're willing to accept that offer.
Okay. I think that makes good business sense for you, and you've come out way ahead of where the legal system would put you. So, in those terms, it's a good decision, and I think they're far above where they thought they would be, but that's where it has to be in order to settle this. So now I'm going to ask you if Chris and Rosanna would get together with me. We'll write up a basic term sheet. We'll initial it so we know it's tied down, and you can go back to your business, and the lawyers will do what's necessary to end the case and to provide the payment. Okay? Congratulations.